And then one more thing, SJ, since I'll be using since I'll be doing the slides, um, I'll need you to add people in who are in the waiting room.
Okay, I'm going to do that. I'm actually going to go ahead and just get started. I'll start at like 12:32. So we're not wasting people's time.
Okay.
So I'm going to start admitting people.
Can you see my thumbnail at the bottom?
Yeah.
Okay, that's fine.
All right, so for those of you who are just joining us, thank you so much for coming. We're waiting for just a couple other people to join. We'll give them a quick 2 minutes to join, and then we'll go ahead and get started. Okay, thanks everyone for joining us for the first of our 4-part series of modern considerations in estate planning. This series is geared towards financial advisors and folks who advise people on wealth management, growing their wealth. Part of what we do at Bilski Chapman is a range of estate planning. But one of the things that I focus on is queer wealth. I call it rich dinks. So what I'm trying to do is make sure that those in the LGBTQ space are aware of how to build wealth and how to keep it. There are some issues that are specific to the community that we're going to go over today. We've got some other presentations, some other great presentations in our Modern Consideration series. My case manager for estate planning in the firm, Josie Shout, is here today, and you can reach out to her for information on the rest of the series. But for now, let's go ahead and jump into this first issue here, LGBTQ plus concerns. So I'm SJ Chapman, for those of you who haven't met me. I'm a partner at Bilski Chapman. I'm the head of the estate planning group. I'm licensed in Illinois and New York, and I've been practicing in both places for the last 10 or 11 years. It's hard to believe how much time has gone by already. I identify as queer, so I count myself to be a lucky member of the LGBTQ community. And this year, we look forward to publishing my book on estate planning for the LGBTQ population. Certainly something that if anyone here is interested in a copy of, you could let me know. We can send you a free copy for any of your clientele who may identify as LGBTQ. Slide. So a lot of us on this call are extremely familiar with estate planning. Some of us have just a cursory knowledge of estate planning and what it is. So before we jump into the modern issues facing the LGBTQ community, I want to go over briefly what an estate plan is. I want to recap what the documents are in an estate plan, what the documents are in an estate plan, and what the purpose of an estate plan is. So in brief, I like to describe an estate plan as a guidebook. It's a guidebook that individuals use to determine what happens to their estate while they're alive and after they die. And a lot of people who come in to see me, who come in to see the financial advising professionals on here, think, I don't have an estate. When they hear estate, they think of, Wayne Manor, Bruce Wayne's mansion with the gates that open up and the Rolls Royce that, the valet drives down the driveway. Well, that's an estate too, but that's the kind of estate that our clients typically have. So an estate is anything that you own. It could be titled property. It could be your car. You have a title to your car. It could be an RV that so many of us, including me, bought during the pandemic. You have a title to your RV, title to your boat, title to your house. Deed is a title to your house. It's bank accounts. It's retirement accounts. It's the dollars in your wallet. It's the pillow on your bed. It's everything that you own. Lots of personal property that we have doesn't have a lot of liquid value to it with an appraisal, but it's got a lot of personal value to us. Family photographs, family heirlooms, things that have been passed down, clothing that has been, wedding dresses that have been passed down from generations. These are all part of our estate, and they're all things that we care about, that our clients care about, that we need to protect during and after life. Slide. So, what are some reasons that people come to us as estate planners? And what are some reasons that you as financial advisors can refer clients to us as estate planners for using the benefits of estate planning? Well, the first is to protect their beneficiaries and their children. Estate plans can be highly versatile. They can account for specific beneficiaries and children's needs. So very often we see in our office one child who's sort of the caretaker child, who families feel that they can leave a little bit more to as the caretaker, or someone who's been particularly close with a family member if they want to leave an heirloom to. But there's also protecting children and beneficiaries from themselves. We have clients with children who have creditor problems, children who have addiction problems, children who are potentially going down the path to bankruptcy, divorce, things that could take property away from them. An estate plan protects those children because it keeps their inheritance with them and not with the third parties that will have that property taken away from them. Gifting of assets. This is another very popular reason that people come in to us to do an estate plan. As I said, both tangible and intangible assets can be gifted this way. So you can gift a painting, you can gift royalties to a poem, you can gift royalties to a song, you can gift a recipe, you can gift a trademarked recipe. So you can give money, you can give anything that you want to be protected, that you value, that you want to pass down, you can gift. You can also, very important, plan around illness or incapacitations. Estate plans, a lot of us think that they're created for death, but they're created for life planning as well as after death planning. A large portion of an individual's estate plan includes planning for illness and incapacitation. And as we'll see today, that is one crucial area that the LGBTQ population needs to understand when it comes to how to make an effective estate plan. Asset protection. This is one of the main reasons that financial advisors should be interested in estate plans, because it ensures that their clients are maximizing the security on the assets that you help them spend their life obtaining. Avoidance of probate, we hear this one a lot. Probate is lengthy, it's expensive, it's a public court process. You can avoid it with an executed estate plan. Minimization of taxes. This also goes back to gifting of assets, but similarly to estate asset protection, estate plans are a way to ensure that your clients can minimize their estate tax on their assets post-death. Paying medical and long-term care bills. The client can use their trust to make specific distributions for things such as bills. Other desires. There's just lots of things that lots of purposes that people have. Maybe they have a family who has a family member who has special needs. Maybe they own a business and they want to make sure that if their partner dies, they don't go into business with their partner's spouse. They get a succession plan to make sure that they can reacquire those shares. Slide. So what are the basic estate planning documents when we talk about an estate plan? Because after all, I said it was a guidebook. And what is a guidebook? But a set of documents. So we've got the will and the trust. These are the heart and soul of the estate plan. The will is only effective after you die. So a lot of people come into us saying, I just need a simple will. I don't need anything complicated. I don't have much. I don't need a complicated estate plan, just a simple will. And we tell them, you probably don't need a will. You probably just need a trust. A will only comes into effect after someone dies. So it really doesn't do very much good. It has to be executed in a signing ceremony where you ask the person a specific set of questions that are in the will statute, in the law of New York, in the law of Illinois. There's a specific set of questions that people have to answer to make this an effective will signing. You have to have the right amount of witnesses. The witnesses have to be in the correct relation to the testator or the person who's signing the will. So very difficult to change a will. And it doesn't do very much for you. It still lands your estate in probate court. A will does nothing but alter the state statutory scheme in the state's respective probate act that decides where property goes after someone dies. That's all a will does. Trust, on the other hand, the trust really zhuzhes the estate plan up. The trust is effective during life. The trust is effective during incapacity. The trust is easy to amend. The only people who sign a trust are the trustor and the trustee. And for our clients who come in who are getting revocable living trusts, that's the same person. So if I make a trust, I'm signing as the trustor and I'm signing as the trustee. How easy is that? It doesn't have to be witnessed, it doesn't have to be notarized. If I want to amend it, I can I can have my lawyer draw up an amendment, sign it in DocuSign within an hour. So easy to change, so flexible. And it really covers all the bases, plans for a lot of contingencies, and it does all the things that I described in the previous slide. It accomplishes all those purposes that people have for estate planning. All of those goals are met via a revocable living trust. That is the document that, when we talk about estate planning, really is the backbone of estate planning. And I'll tell you a little bit more about the trust on the next slide. So it makes sure that the property that our trust maker has goes to the right people. Make sure it goes to the right people at the right time. Okay, this refers to how and when the trust maker would like their assets to be distributed to beneficiaries. For example, we don't want to give all our property to someone when they turn 18. What are they going to do with it? I know when I turned 18, what I would have done with it, I would have bought a horse to go along with all of the horse accoutrement that I had at that point. I had the halter, I had the saddle, I had the grooming brushes. I just didn't have a horse because I couldn't afford it. All I could afford was a, curry comb here and there. That's not a great use of my money at 18. Much better use would be college, right? So making sure that your beneficiaries get their money at a time that's appropriate for them to make decisions, informed decisions, mature decisions about what to do with their property, with their inheritance, is really crucial. A lot of what our estate planners do is they will divide property up into thirds. They'll say, my child can get their inheritance in thirds. They'll get 1/3 when they turn 25. They'll get 1/3 when they turn 30, and they'll get the rest when they turn 35. This also protects against divorce. So if a child gets married at 25 and they get divorced before 30, 1/3 of their inheritance is going to be their money that they've inherited that then is going to be subject to equitable distribution between two spouses. So 50% of what they've inherited from our clients might go to a divorcing spouse. But that's okay because we've already saved 2/3, we've already held 2/3 back to be distributed later in life. So that's a way that we can protect our beneficiaries, make sure that it's getting to the right people at the right time and keeping the wrong people out. It's also a great tool if our clients are disabled. The trust specifies how much money to be used for your care, whose priorities, whose needs to be met first in prioritizing how the money is spent. And then, of course, the trust also is in effect after someone passes away, and it can specify how the money is used for beneficiaries. And people can put all sorts of stipulations in. We have someone who went to a Big Ten school who said, if my child goes to any of the other Big Ten schools, they're not getting college paid for. And that's fine. That's their choice. And that's what you're able to do with a trust. You can make it really, really flexible. Slide. Like I said, you can avoid probate. In Illinois, you need probate if you have over $100,000 in assets. In New York, you need probate if you have over $30,000 in assets. Probate will cause delays. There's a long delay in decision making because it has to go through the court process. Probate's completely public. Everyone sees who you gave what to. It's costly. Claimants can come after it. Claimants rarely come after clients when they put everything in a trust. If you're unmarried, it can protect against the claims of your live-in partner and their beneficiary. If you're married, a trust reduces or eliminates estate taxes. That's great news for our clients who are protecting the wealth that they've spent a lifetime building. And like I said, it gives asset protection for your beneficiaries. Slide. Now, there are some documents that are often overlooked when we think about the importance of the estate planning guidebook. The power of attorney for property, power of attorney for health, your living will, which a lot of people refer to or know as a DNR, do not resuscitate, and your HIPAA release. And these are going to come into play when I start talking about the interaction of estate planning with the LGBTQ community. Slide. So why is it important for advisors and estate planners to understand LGBT estate planning issues? And I have a little asterisk here to say there is a whole alphabet involved in LGBTQ identification. I'm going to say LGBT or LGBTQ for short. This is not to the exclusion of anyone. It's just for brevity's sake. So today, 7%, and this is from Pew Research, 7% of adults identify as LGBT, but we've got 21% of Gen Z identifying as LGBT. So we can see that the identification rates are going up. Combined with that, 30% of adults believe you should have a will before you're 35. Well, everyone on this call knows it should be a trust, but you know, that's the importance of estate planning. 1/3 of people know about it. Slide. So there's a clear upward trend in the amount of folks who are identifying as LGBT, and you can see that it's skewing younger, right? And these are the people that we want in our practices. They're the people who are building wealth. They're the people who are going to take our advice because they haven't had an advice, a counselor or an advisor in the past. So it's really, really important, crucial to know these issues. As advisors, you're going to have more people who come in who are either openly queer or identify as queer and don't want to talk to you about it. But these issues are still important to know and to advise everyone of. A slide. So just to reiterate, the trend and the millennial population is increasing in the number of people who are identifying as queer, and more and more, I think that's just going to keep going upwards as there's more acceptance, more tolerance, more equity, more diversity, more inclusion in our society and in corporate America for the folks who are really building wealth. Slide. All right, so we're going to add a little bit of a humorous twist in here for it. So you're not going to take my word about being LGBT and having concerns about estate planning. You're going to take Trixie and Katya's. So Josie, you can double click on the picture, of Trixie right there. Oh, we can't hear it. It might be because you're muted. Let's see.
Yeah, let's try unmuting.
Oh no, it's still not working. All right, let me see if I can share my screen for 1 second.
All right.
It also makes being a gay man dying terrifying, because I think part of what makes you comforted to die is that you have family leaving legacy, children, etc. If you're a gay man and you have no children and you just die, you're like, I was a waste of life.
Oh, I don't think so. I
You
think
don't?
No, I just feel like there's no bad.
Oh, honey, just honey, shoulder pads, honey, and just this, honey, honey. Let's do this too. What about dying?
Oh, I don't know. I just,
Oh, no, honey, no, dying, honey, dying, honey. Honey, when I want to die something, honey, I put my white wig in the wash machine with a red shirt, honey.
Okay, Josie, you can go back to sharing.
I love.
So that was adding a little humorous twist. But of course, this is a serious concern. There are serious concerns that are addressed by estate planning for those in the LGBT population about where their assets will go post-death and how they will be taken care of during their life. So luckily, we know that with estate planning and specifically trusts and the other estate planning documents that we mentioned, there are lots of options for lifetime and post-death planning. Slide.
Sorry, SJ, now it's not letting me change slides. Just give me a second.
Okay.
There we go.
Okay, so 3 of the main issues that I'm going to go over that I want to address that are modern considerations in estate planning specific to the LGBT population are discrimination, guardianship, and marriage concerns. So a lot of times we think about estate planning as just preservation of wealth, but for our queer clients and queer folks, it's really much more important than that. Estate planning is much deeper than that. Slide. So the first is healthcare discrimination concerns. So according to Human Rights Watch, queer patients report a multitude of experiences with discrimination. They're denied fertility treatment, denied counseling, denied routine screening, denied pediatric care for their children. 15% of LGBT patients postpone or avoid medical treatment due to fear of discrimination. The trans population in particular suffers from even more pervasive discrimination. And I think we've all seen this with all of the hateful laws that are coming out and being passed today. I mean, it's really scary. 3 in 10 people who identify as trans postpone or avoid medical treatment due to discrimination. And 1 out of 3 report the need to teach their own medical providers about their gender identity in order to receive adequate care. It's completely backwards. The next thing I want to touch on is guardianship concerns. So this is from a website called surviveonthishore.com. It's got really great interviews with people who identify as trans. Now, if we're incapacitated and we don't have a power of attorney for health, then a judge is going to appoint a guardian for us. And who knows whether that guardian is going to be an ally, whether that guardian is going to understand and even advocate for gender affirming care. So this is a picture of someone named Mitch from Seattle who did an interview with to Survive on This Shore. And he talked about seeing his dad age and go into memory care. His dad had Alzheimer's, and it affected him because he thought to himself, by the point at which you are no longer able to make decisions and you begin forgetting things. He said, what if I forget that I'm trans? If they're dressing me differently in this place because of my body, then how am I going to know the difference and who's going to advocate for me? So it's really important to have decision makers who are gender affirming, who are allied, who will be an advocate for the type of healthcare that LGBT folks need put into place beforehand. Slide. And the next concern is marriage concerns, right? we probably on this webinar have all heard about the Dobbs decision. That's in a long, long line of jurisprudence regarding rights and granting human rights to people that looks like it may be starting to get unwound. I mean, I think 10 years ago, we all thought that Roe v. Wade was really just almost black letter law that was never going to get changed. And then unbelievably in 2022, it was overturned. And it's hard to believe that it's been such a short time, but same-sex marriage, as it's called, has only been federally protected since 2015. That's less than 10 years old. Well, if Roe v. Wade is at risk, then that's at risk too. So having an estate plan can really be a fantastic proxy for being in a marriage. The other thing is for our the folks in the queer community who are non-monogamous, or also known as polyamorous, who are in long-term committed relationships with more than one person, there's no law set up for that. There's no law that protects the right of someone's two spouses instead of just their one spouse. Estate planning can do that. So we'll get to that slide. So let's talk about why it's so important to refer your LGBT clients to an estate planner. For the reasons I just went into, a little bit further explanation. So for that gender affirming care, for when someone is incapacitated, when they have a disability, when they need someone to advocate for them in the healthcare space because they can't advocate for themselves, they need a healthcare power of attorney appointing trusted agents who they know will advocate for the correct healthcare for them. We do not want to leave this up to the court to decide, right? We all know the direction that court is heading. We don't want courts to pick who guardians and advocates for our LGBT clients will be. This is hugely, hugely important. So when we're talking to our LGBT clients about their wealth, we also want to talk about the great benefits that a healthcare that powers of attorney can have for them during their life. And then let's talk about how we can use trusts to, in the event that the right to marry is eroded. You can basically set up a marriage by proxy with the same financial rights that two spouses have when they're legally married under state law. So if that legal right to marry goes away in one or more states, we can recreate that by proxy using an estate plan. And for non-monogamous partners, life partners, spouses, whatever it may be, we can use partnership agreements to also replicate the rights of married couples. I have a friend who got divorced from his polyamorous group last year, and he was like, it was a nightmare unwinding everything, right? You have to unwind finances. You have to decide who gets the pets. You have to decide who's going to pay for what. You have to decide where people are going to live. So by having these plans set up in advance, it can really protect the partnership, right? Everyone is very excited when they're entering into a partnership that nothing is ever going to go wrong. And that's why we want to put these agreements in place, because it can protect partnerships no matter what the laws are. Slide. All right, so that's the main gist of why it's so important as a financial advisor to be on the lookout for clients who identify as LGBT or queer, and to talk with them about these issues and say, look, you've got some life savings here that we've invested for you, but there are really some, you should talk to an estate planner about protecting those assets and making sure they get to where you want to go. But there are some other really, really big considerations that the LGBT population is facing that an estate planner can tell you about and help you to put documents in place to protect you and your loved ones and what you spent a life building in wealth. So does anyone have any questions about this topic, estate planning in general, the intersection of queer wealth or queer lifestyle with estate planning? You can just hit the raise your hand button.
I have a question for you, SJ. So, as a financial advisor, financial planner, if I have a individual client who is a part of the queer community and they don't have a partner or say someone to take over as a power of attorney, what other options would they have in terms of designating someone for a power of attorney?
It's a great question. And we do see this a lot. We have lots of single folks who are heading towards retirement or who are retired. And let's be honest, estate planning is kind of on the end of everyone's to-do list. So some of our clients are queer, some of our clients don't identify as such. But for those folks, we always say, who is a trusted friend that you have, right? So we have folks who don't have children, who don't have living siblings. What we tell them to do is they look to a trusted friend. They look to their trusted community. Also children of trusted friends. So making those connections with not only peers in the community, but also folks who are sort of one younger generation away from those peers, because we know that those people will be around when the person dies, right? They know they'll be around and capable for every every time period that decisions need to be made. Oh, thanks, Ricardo, for pointing that out. Yeah, I said spouse. Some of our clients actually do refer to their partners as their spouses, even though it's not legally binding under state law. But we do have clients who introduce as wife or husband in the spouse sense, even though they're not legally married under state law. So you're right, under state law, there can only be one spouse. So you can have multiple partners, multiple beneficiaries, but estate planning certainly will help to protect the rights of those who you consider to be your spouse, to whom you've made that, sort of lifelong commitment that we think of initiating the spouse relationship. Okay, well, we're keeping track of everyone who attended the webinar for continuing education credit. So after the webinar, attendees who want to receive continuing credit will be sent a certificate of completion within 14 days of today. And then we just ask that if you know anyone who's interested in attending our webinars or a financial advisor looking to obtain continuing education credit, to please keep us in mind. Please feel free to give them our information. My contact information is on the slide. Josie, my case manager, also was here today co-hosting with me. She's incredibly experienced in estate planning, very knowledgeable, and can answer questions, and works with a lot of financial advisors on issues around estate planning and making connections and referrals and business partnerships there. So we are here as a resource to you for anything estate planning related. And thank you so much for attending today. And hopefully we'll see you all at the next Modern Consideration series in estate planning.